that probe, remember, it's been back and forth. Liberal Oshomah joins us today. Thank you for coming on again today.
My pleasure, as always. Thanks for the opportunity.
All right, this probe now, because that's the last time the Speaker of the House of Representatives has instructed that, yes, they continue with the probe of the ministry. Remember that there was that quote-unquote court injunction trying to prevent them from going ahead, but they said, no, they've checked, they've cleared the air, they're proceeding. And now we're hearing all sorts of things. What do you think about this probe?
What I think about the probe is different from what is actually happening. Unfortunately, what we have here, you have people who are custodians of the law, but who largely respects the law. We had some situation in this country where the Supreme Court would deliver a judgment, and then the government would tell you, we are still studying the judgment, or that we will need interpretation on the judgment, or situations where the Attorney General of the Federation would be acting or sitting on appeal on a Supreme Court judgment. It's a tried principle of law, really. To every lawyer, even a year one lawyer knows that once a matter, it's sub judice, a matter is before the court. Just the same way you don't go into the merit or demerit of the matter.
What is sub judice about this one?
If parties submit a matter before adjudication, for adjudication before a court.
Yeah. Has this one been submitted before the court?
Yes, from what even the House of Rep did say that the matter is in court, but that injunction, initially they said injunction was granted, and later, okay, they have come to the realization that injunction wasn't granted. But the principles of law that we know, whether an injunction is granted to restrain you or not, once a matter is submitted before the court, most especially when the determination of that matter will also determine the extent you can go in handling, whether it's a probe or whether it's a tenancy matter.
Okay, but
you should, at a mark of respect to that arm, the judiciary.
What is the
action?
What is the prior?
That's why in some cases the court will tell you.
Okay, let me jump in.
Even though I refuse or restrain from granting a restraining order, but parties should maintain status quo.
What is the prior in this case? Is the minister trying to stop the House of Reps from probing her?
I think from what I have gathered, two basic planks, whether the comments of the House of Rep had not passed judgment on the minister before even probing into the matter, and also whether the powers of the House to probe, the powers in Section 88 and 89 of the 1999 Constitution to probe, whether it is investigative or inquisitive, and
oversight.
Or oversight. Where does oversight start and where stop, and when does witch hunting start?
Is there anything wrong in what they're doing, legally speaking now?
I would draw from the judge's pronouncement in Sanusi's matter, and he said that a cockroach that is called to defend himself in the midst of chicken, there is no way that cockroach is going to have fair hearing, because when you condemn your victim, or you are prosecuting a matter and you condemn the accused person even before you have the opportunity to look into his defense, the tendency that accused person will not get justice or fair hearing before you, it's very high. That's why in most cases,
that's an assumption.
Yes,
and in
that's
this
why
case,
in most cases,
they're not in court.
No, wait,
this is the House of Reps.
Chamberlain, wait. That's why in most cases, even when a judge sits on trial, because that power gives the House of Rep, that section gives the House of Rep a quasi-judicial function. And so that's why, as a judicial officer, when you sit on trial, we are also on trial. That's why you should, as much as you can, refrain from delving into the arena. That's why most times we tell judges, my lord, refrain from going into the arena. Look at the fact and look at the matter.
These are two separate things.
No, they are not.
The first scenario being the court. The second, the House of Reps.
No,
and we both...
And the House of Reps performing a quasi-judicial function.
No, but the House of Reps...
Is the key word there.
Yes.
So, Liberals, Oshomah. We want to know that when we saw, someone not doing what he ought to have done properly, we remember what happened with the probe of SecDG into the accounts of the Securities and Exchange Commission, and we saw what was happening there. It was only justifiable, the events that took place thereafter. It made it even more believable when the accusations were made, because a host of people were wondering, where is this probe going to? It seems it already had a predetermined conclusion even before,
inviting the SEC.
Exactly. But a host of people will tell you that, we all knew what was happening in terms of what had happened in the subsidy matter. There were strands of facts that was available to us before the probe itself took place. And, we knew that certain things would definitely come out. Well, we didn't quite realize the extent of it until that particular probe. Are we saying that, the House of Reps, it's taking these decisions owing to certain facts that have come out, or owing to certain information, I don't want to call them facts now, owing to certain information that have come out? Are you saying that that itself, already takes it to a decision?
Well, you see, it's as politicians, we really don't know when to draw the line between performing a function, either as a quasi-judicial officer, either as a legislature, or as a politician. That's a problem we have.
But
for a judge, it's always very easy. If, for example, I'm standing trial before a judge, and then let's say like the case of Al-Mustafa, if you remember, and then the defense lawyer applied that the accused be allowed to sit down in court. And the judge said, I will not allow criminals sit down in my court. And that alone, that word alone, means what this lawyer simply did was to apply that the judge excuse himself from the matter, because you have passed judgment on him even before listening to his defense. In this case, if you remember when the matter started also, I've taken the pains to follow this event. And then, if you remember, the statement credited to the House of Reps said, an official of government could waste public fund on such luxury. It means, by implication, what you have done, and this is somebody who has been called upon to look into the matter, the merit and demerit of the case, and report back to House. When you passed such judgment, what it means is, look, even if I come before you, you have already said I've committed this act.
Is that the chairman of the committee?
Yes. That's a statement credited to the chairman of the committee. And it's not everybody that has the kind of courage that Oshomah had. It's not every woman or every man that will be able to face, some honorable members to say, look, I will not take this from you. Some people would say, look, from your statement, it is very obvious that all you're just going to do is to make a show of me. So I would rather go to a different arm of government to look at these issues independent of you. And if that happens, what you do as a lawmaker is to say, okay, now that you have run to equity, let's see how equity will handle the matter. I sheath my sword. Let me go and prove my case before this other arm of government while you prove yours. And let that arm of government decide either this way or otherwise.
Which arm now?
The judiciary. Because what is at stake here is your powers to look into this matter. Where does it stop? Are you going to be performing the duties of a prosecutor, an accuser, a prosecutor, and a judge?
Okay, but
to allow the court to determine all of this.
But we know that.
I think that's what is playing out here.